God save the state and this honorable court.
Good morning. The first case is State v. Hague, and we'll hear from the appellant.
Mr. Chief Justice, Associate Justices, may it please the court. My name is Jeremy Lindsley. I'm an Assistant Attorney General with the State of North Carolina Department of Justice. It's my honor to represent the people of the State of North Carolina in this matter. We're here this morning because on September 7th, 2020, the defendant shot and killed Tommy Cass in an empty cornfield in Iredell County. At his trial, the jury found defendant guilty of first-degree murder, and he was sentenced to life in prison without parole. Following his trial, the defendant appealed, claiming that the trial court erred in three ways. First, defendant asserts that the trial court erred when it denied his motion to dismiss based on insufficiency of the evidence of premeditation and deliberation in support of the first-degree murder charge. Second, defendant asserted that the trial court erred when it denied his request for a stand-your-ground jury instruction. And finally, defendant asserted error on the part of the trial court for exclusion of his testimony that he knew that Tommy Cass, the victim, was a convicted felon. Now, in the court below, the court reached split decisions on that first issue, the sufficiency of the evidence issue, and on the third issue, evidence of the felony conviction. Judge Stating dissented from the majority on those two issues. With regard to the third issue, the court issued a unanimous decision on the stand-your-ground instruction issue. That issue was decided in favor of the state. The first and third issues were decided in the defendant's favor. So the state has appealed to this court on the first issue and the third issue, and the defendant has appealed to this court on the second issue. The pertinent facts of the case are as follows. On September 7th, 2020, Tommy Cass, three of his friends, and his son went to a field, a cornfield in Iredell County, to go dove hunting. This was a field where Tommy Cass and his friends would go with some regularity. He was not a stranger to this cornfield, which was owned by a third party, and in which Tommy Cass had permission from that owner to hunt on the property. The property, the cornfield, is across the road and down about 100 yards from the defendant's home, where the defendant runs a equine rescue business. On the morning that this occurred, Tommy and his hunting party were in the field getting ready to hunt for the day, and the defendant testified that he heard a couple of gun blasts. And what he did was he got up from bed, he got dressed, he grabbed a pistol, and he drove out from his home to the cornfield to confront whoever was there, because he was concerned that the gunshots might harm one of his horses. Now, that had happened in the past. Even, in fact, it was a hunting occasion in which Tommy was there with another group of individuals when a gun blast did hit one of his horses, injuring that horse. That occurred some 2 or 3 years before September 7th, 2020. So the defendant drives out to the cornfield armed, and when he gets there, he confronts one of the hunting members and Tommy's son, who arrived there after the other hunters had arrived. And according to Tommy's son, the defendant was angry when he got there. He was mad. And he told the defendant's son, Thomas, that they couldn't hunt there. They didn't have permission to be there. To which Thomas informed him that, yes, indeed, they did have permission to be there. And defendant said, well, you don't have permission to shoot my horses, which at this point hadn't occurred and never occurred during this scenario. After hearing that, defendant talked with another member of the hunting party and learned that Tommy was in the field. So defendant took it upon himself to walk into the field to go talk to Tommy. No one invited him to do that. He entered the field, walked an unknown exact distance, but some distance down the road into the cornfield. And a conversation then occurred between defendant and Tommy Cass. Now, that conversation was a contentious one. Tommy was upset that defendant was once again bothering him and his hunting group about hunting on the property. Apparently, this is not the first time that the defendant had interfered with Tommy's group hunting on that property, again, on which he had permission to be. Well, ultimately what occurred is Tommy Cass pushed the defendant with both of his hands, causing the defendant to fall onto his back. As the defendant was getting up, he said to Tommy, "That's a classic felony on a disabled veteran." And according to the defendant, Tommy started to walk back toward him and began to reach into his vest or jacket. And the defendant, as he was getting up onto his knees and collected his cane, he had a cane and was wearing a boot on his leg, on his foot, collected his cane, made that statement to Tommy, and as he did that and alleges that Tommy was coming toward him, reaching into his coat, he remembers that he had brought his gun, which was in his back pocket. And so he reaches to his back pocket, he grabs his gun, and he shoots Tommy one time, killing him instantly. Now, there's conflicting testimony from Tommy's hunting mates, one of which, Grant Evans, was the closest member of the hunting party to this incident. And according to Mr. Evans, Tommy had stood where he was after he pushed the defendant. And when Tommy saw the defendant drawing a gun, Tommy put his hands up and said, "Whoa, whoa, wait a minute," before he was shot. No weapon was found on Tommy's body after the fact, but what was found was a handwritten note from the property owner that said, "Tommy Cass has permission to hunt on this property." Now, at trial, defendant made a motion at the close of the state's case, and again at the close of the evidence, to dismiss the case based on insufficient evidence of premeditation and deliberation. And here the Court of Appeals agreed with the defendant and found that the trial court erred in denying that motion. The state contends that the Court of Appeals erred in overturning that decision by the trial court because the standard for getting past a motion to dismiss is very low. And it's a standard that I know this court is well acquainted with. All that the state needs to show is substantial evidence, which is enough evidence that a reasonable person might accept as adequate to support a conclusion. So the conclusion that the jury would have had to have reached here with a first-degree murder charge is premeditation and deliberation. The evidence must be viewed in the light most favorable to the state and giving the state every reasonable interpretation and every reasonable inference to be drawn from the evidence. If there are contradictions or discrepancies in the evidence, that's for the jury to resolve and does not warrant granting of a motion to dismiss. The state contends that the Court of Appeals failed to adhere to those standards and instead engaged in weighing the evidence rather than considering the evidence in the light most favorable to the state in deciding that there was insufficient evidence to support premeditation and deliberation. So what is the evidence of record to support premeditation and deliberation? We know that the defendant left his home with a gun. Now, according to the defendant, it was his habit to bring his gun everywhere he went. There was no conflicting testimony about that. But in the shoes of the jury, who are in the best position to assess the credibility of witnesses, including the defendant, is in the best place to determine whether or not the defendant was being honest with his answer. Nevertheless, the defendant brought a gun to the field, knowing that there were hunters with guns in that field. And at the time he left, he didn't know who was in the field. So he's expecting an encounter of some kind with folks in the field with guns. He brings his own gun. When the confrontation occurred after the defendant was pushed, there were several seconds, we don't know exactly how many seconds, but several seconds between the time that defendant began to collect himself, getting to his knees, finding his cane, making that statement to Tommy, continuing to stand up, and then reaching into his back pocket, pulling his gun, and pulling the trigger. Now, in the light most favorable to the state, that is sufficient time to form an intent to kill Tommy. This court has held many, many times that it doesn't take much time, very little time, to form the necessary intent to kill. In fact, the time is so small that it's sufficient if that intent is formed between pulls of the trigger. And in this case, much more time elapsed than simply trigger pulls. More than sufficient time after being pushed and confronting Tommy for him to come to the conclusion that he wanted to kill Tommy. One important factor that the court should know. These two were not strangers to one another. Even before this happened, in addition to the occasion where the defendant's horse was shot, these two had a couple of encounters at local businesses, one at a Subway, one at a 7-Eleven. State contends that there's evidence that these encounters were contentious. They weren't friendly meetings between these two parties. And in the light most favorable to the state, the evidence, which I will explain, is sufficient for this court to find that there was some evidence of ill will between them, a history of bad feelings between these two. In one incident, the defendant told Tommy that he wasn't allowed to hunt on that field, even though he knew otherwise. And on another occasion, he encountered Tommy, and Tommy made comments to him which were derogatory toward police, judges, and retired police, to which defendant said, well, I'm a retired cop. And patted Tommy on the shoulder and said, be careful out there. And he left. And he left because he recognized that there was bad blood there. He left because he wanted to avoid, according to his own testimony, he wanted to avoid a further encounter. He left so that nothing bad would happen. With that history and this confrontation in the field and the evidence that this isn't the first time that he's encountered Tommy and told Tommy he wasn't allowed to hunt on this field, is sufficient evidence to show ill will between these parties, which is one of the factors that this court can consider in determining whether or not there's sufficient evidence of premeditation and deliberation. The additional evidence, there's evidence that that defendant was angry when he arrived. He wasn't calm. He had already worked himself up. There was time in between him getting up and his pull of the trigger, enough time for Tommy to put his hands up and say, "Whoa, wait a minute," before he was shot. Sufficient time existed for the defendant to form an intent to kill Tommy.
But aren't you essentially arguing to us that any intent to kill is premeditation? And that's not the law, right?
Correct, Your Honor.
And then the Court of Appeals, in its opinion, outlined, do you agree that it's a totality of the circumstances test for whether or not there's sufficient evidence of premeditation?
I agree with that. It is a totality of the circumstances test.
And the Court of Appeals set out 8 different circumstances that they say courts typically look at, and they say you shouldn't give any preclusive weight to any one of these. You look at all of them in their totality, correct?
That's correct. But the list that's in a lot of the cases is not an exclusive list. It's not necessarily the all-encompassing list.
Right.
And I'm sorry, go ahead.
No, please continue your answer.
If you're weighing the evidence in the light most favorable to the state, all that's necessary to get past the motion to dismiss is a scintilla of evidence, enough so that a reasonable person can make a decision based on that evidence.
So is a scintilla of evidence the same thing as substantial evidence?
When you weigh all the evidence in favor of the state, if there's sufficient evidence of ill will, animosity, of time enough to form the intent to kill, that could be enough to establish premeditation and deliberation to get past a motion to dismiss. It's an issue for the jury to decide whether or not the evidence satisfies, beyond a reasonable doubt, those requirements. The jury decided that in this case and found the defendant guilty of first-degree murder. When it had the option to find him guilty of second-degree murder, chose not to do that, and had the option to convict him of voluntary manslaughter and chose not to do that. So the jury, having heard this evidence, was convinced to pass on the most serious of the charges that were presented to it.
On the sufficiency of the evidence question, is there any shortcoming in the legal analysis that was engaged in by the dissent?
I agree with the decision reached by the dissent, and I think it applied the correct analysis and incorporated sufficient factual reasons for departing from the majority. The judge stating mentioned the animosity or ill will between the parties, the gun in his back pocket, that he was angry when he arrived, that Tommy had already put down his shotgun, didn't have anything in his hands at the time that he was shot, and that Tommy had time to say, whoa, wait a minute. That was enough and should be enough to establish premeditation and deliberation.
And don't we have case law that says scintilla evidence is essentially the same as substantial evidence?
Basically, yes, we do. It's a very low bar, necessarily so, to get past a motion to dismiss. Otherwise, a defendant could come up with any number of theories of innocence which might explain away the reasons, but the court's not supposed to consider that. The court's supposed to consider whatever the evidence is in the light most favorable to the state. The Court of Appeals didn't do that here. And so we would ask
Did the
that-
dissent? Did the dissent
Did the dissent consider?
view it in the light most favorable?
Yes, absolutely. Judge Stating decided that all of those factual elements that I listed were enough to get past that scintilla of evidence, sufficient substantial evidence bar or level, which again is necessarily low. I'd like to turn to the other issue appealed by the state in this case. That is the trial court's decision to exclude testimony, the defendant's testimony of his knowledge that Mr. Cass was a convicted felon. Now, the fact is that the defendant only knew that Tommy was a convicted felon. He did not know what those convictions were for. As the trial judge pointed out several times during the trial, being convicted of a felony isn't really probative of anything. A person can be convicted of, as the trial court explained, littering over 500 pounds could be a felony. Another example is in this state, if you harvest a Venus flytrap, that's a felony. Now, those felonies don't really inform anybody about the person who committed it, other than perhaps that it's a felony. It certainly doesn't suggest that the person is violent or the type of person that should be feared. The defendant in this case wanted to introduce that testimony to explain or show the reasonableness of his actions in shooting Tommy. The argument is by the defendant that because he knew Tommy was a felon, he had reason to be fearful of Tommy. And therefore, shooting him because of that fear was a reasonable thing to do under the circumstances. But because the defendant only knew that Tommy was a convicted felon, he didn't have any reason to be afraid of him. Not only that.
Isn't there a slight tension, though, in what you want all this evidence and you want us to take in the light most favorable to the state that there was a contentious arguments and disputes between the victim and the defendant, and then standing up here arguing to exclude parts of a 911 call that go directly to defendant's state of mind and that contradict the position you have about the contention between them. I mean, I can't reconcile the fact that you're alleging these men are fighting, and then you're also saying, well, defendant would have no reason to worry about this at all.
Well, the defendant himself testified that he thought their relationship was okay, that there was no real serious animosity between them. He had said that on the occasion he encountered him in the store, Tommy was just having a bad day. And during the trial, the defendant testified that he knew Tommy often carried guns. He had seen him on a couple of occasions with pistols. That apparently didn't cause defendant any concern, but now he wants the jury to believe he's afraid of Tommy because he's a convicted felon.
Yeah,
That's
but I
not
guess
enough.
what I'm saying is we're taking the evidence in the light most favorable to the state, so we are not assuming that the relationship is good. If we're doing what you ask on the first issue, we're saying, yeah, these guys had a real contentious relationship. So do you see what I'm saying? If the contradiction I'm struggling with in your argument?
I do. I think in this particular instance, um, again, this is a question that the jury is in the best place to evaluate whether or not they believe the defendant, whether they think he had reason to be fearful of Tommy. These encounters at the store, even though the state would characterize them as contentious, they weren't necessarily to the level of having to defend yourself by shooting somebody. In this scenario, we're under very different circumstances. So if the defendant had any fear, which he says he didn't, of Tommy, it certainly wasn't to the level that he would have had to have shot him. And here's the main point. In State versus Strickland, and here I have to point out a citation error in the state's brief. In a couple of places in its initial brief and in its reply brief, there was a quotation attributed to State versus Smith on page 35 of the initial brief and page 7 of the reply brief. There's a quotation there, which belongs to State versus Strickland, 346 NC 443. And in Strickland, the court said, where a defendant seeks under Rule 404B to use evidence of a prior violent act by the victim to prove the defendant's state of mind at a time he killed the victim, the defendant must show he was aware of the prior act and that his awareness somehow was related to the killing. Here, the defendant was not aware of prior acts. He was only aware of Tommy's status as a felon. The court below excluded this testimony because it didn't find it relevant under 404B. Didn't find that it fit any of the exceptions under 404B, which was the correct decision because this is not testimony about prior wrongs, acts, or crimes, as Strickland would expect. This was just testimony about status as a convicted felon, which the state suggests is not enough. I will quickly...
I'm sorry, before you
Yes.
switch, sort of a similar question. Is there anything legally deficient in the dissent's analysis of this evidentiary issue?
I don't believe so. No, sir. On the second issue, just very briefly, in which the court below unanimously held in favor of the state, the stand your ground instruction and statute applies to a person who's legally or lawfully present in the place where he is when the incident occurred. The court below correctly found that there was no evidence that the defendant was in this cornfield, which he did not own, lawfully, and therefore that instruction was not appropriate, and the court correctly declined to give it. I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
May it please the court, my name is Sandra Haygood, and I'm here on behalf of the defendant, Blaine Dale Hague. As much as I would like to jump into discussing some of the issues that my colleague has brought up, I would like to first start with the issue on which Mr. Hague is the appellee, and that is the jury instruction issue. To paraphrase Justice Martin in his concurrence in Lee, this case is about what a man did in the few seconds after he suffered a violent assault and saw his assailant coming back for him and reaching for a gun. This court now has to consider that man's response to this violent event in light of the doctrine of self-defense under our stand your ground statute. Mr. Hague is an elderly Vietnam veteran. He's a retired detention officer with Iredell County Sheriff's Department. That day, he had a cast on his leg and was using a cane to get around. He has vertigo and diabetes. He was put in fear for his life and believed he only had seconds to respond or be killed. He is exactly the person that the stand your ground statute was meant to protect from criminal liability. He was a law-abiding person. He had done nothing wrong by being where he was, but because of the criminal acts of someone else, he found himself needing to use deadly force. He did not go onto that field to rob or steal or commit any crime. Instead, unlike Tommy, who was committing several felonies that day, Tommy was a felon in possession of a firearm. He was an unlawful user of oxycodone, a controlled substance, so he could not legally possess a firearm for that reason either. He also possessed a controlled substance that wasn't prescribed to him, and because he had a previous state felony drug conviction, that's also a felony. And this is all before he violently attacked Mr. Hague, who the state admitted had done nothing but speak to him and certainly had done nothing to provoke him when Tommy responded with a violent assault. Mr. Hague went onto the neighbor's field. He testified over and over again, merely to request, not to confront, but to request that the hunters move further away from his horses, because in the past, a horse of his had been shot by a hunter in the same field. And that morning, after the gunshots were fired, that horse was tearing around, and Mr. Hague feared was in great danger of injuring herself. He merely wanted to request. He did not go there to fight. He went there to request that especially the hunter who was right by the road simply move further away down the fence line so he wouldn't be right across from Mr. Hague's horses. In light of all of this, the question for this court is whether or not the trial court erred by refusing to give Mr. Hague the right conferred on him by our legislature to stand his ground and not retreat, by refusing to give a complete self-defense instruction. This court's opinion in Lee and Bass are controlling here, and under this court's opinions in those two cases, Mr. Hague was entitled to the full self-defense instruction. First of all, as the trial court pointed out, there was, he literally said, quote, there was no evidence one way or the other about whether Mr. Hague had permission to be on the field. So it's possible that he did have permission to be on the field. Secondly, he put on evidence showing that he went there for a lawful purpose, which was merely to request the hunters move further away from his horses to prevent serious injury to the horses. And thirdly, because the state failed to meet its burden to prove that Mr. Hague was not entitled to the instruction. It is the state's burden to prove self-defense, to disprove self-defense by a reasonable doubt. And it was the state's burden to show that Mr. Hague was not entitled to this instruction, and the state failed to meet that burden. Furthermore, In Lee and in Bass, this court made clear that the language of the statute requires that the stand your ground law be read to confer the right to stand one's ground if a person is, quote, any place the citizenry has a general right to be under the circumstances. The court went on to say, contrary to the opinion below, the phrase, any place he or she has a lawful right to be, is not limited to one's home, motor vehicle, or workplace, but includes any place, again, the citizenry has a general right to be under the circumstances. And this court quoted the summary of ratified legislation that said a person wherever located has no duty to retreat. Nonetheless, contrary to this court's interpretation of the statute in Lee and Bass, both the trial court and the Court of Appeals proceeded on the assumption that the statute requires some special legal entitlement to be lawfully present. But that is not in the statute. And even if it were, even if the statute were ambiguous, and it's not, under the rule of lenity, it must be construed against the state. And as a remedial statute, it must be broadly construed to accomplish its purposes. The Court of Appeals and the trial court assumed that since Mr. Hague was on private property, and as far as we knew, it wasn't proved one way or the other, without express permission, he was not lawfully present. But this is an error of law, as I demonstrate in the brief. The trial court and the Court of Appeals treated the fact that he was on someone else's property, as far as we know, without explicit permission, as if that ended the analysis, but it didn't at all, because as I demonstrated in my brief, there are many ways that a person can be present on someone else's property without explicit permission and still be lawfully present. The Court of Appeals and the trial court also compared and weighed Tommy's right to be there, Mr. Hague's right to be there against Tommy's right to be there, but there's nothing in the statute about the relative weight of the victim and the defendant. There's nothing in the statute to justify that approach. And finally, on this issue, the evidence must be viewed in the light most favorable to the defendant as it appeared to him at the time of the incident. In other words, what did Mr. Hague think that he was doing that morning? He did not think he was going there to commit a crime or do anything against the law. He believed he was entering the field for the simple purpose of requesting the hunters to move down further away from his horses. Of course, also, then we have to consider prejudice, a reasonable possibility that the outcome would have been different. In both Lee and Bass, this court held that omitting the stand your ground language from the jury instruction led to, quote, an inaccurate and misleading statement of the law. And in Bass, this court did not go any further in its analysis of prejudice, but relied on the inaccurate and misleading statement of the law as the prejudice in and of itself. In Lee, this court did discuss prejudice more fully, but in that case, this court held that there was prejudice because the stand your ground instruction informs the determination of whether the defendant's actions were reasonable under the circumstances, which is a critical component of self-defense. Clearly, the jury cannot determine whether the defendant's force was excessive, unnecessary, or unreasonable without knowing the degree of force the defendant was entitled to use. In a sense, it's a weighing And you can't say what's excessive force if you don't know what the allowed force was. So it seems very clear that there's definitely prejudice here. And that's why the Court of Appeals engaged in circular logic by saying that there couldn't have been prejudice because the jury necessarily found that the force was excessive. But the jury found that the force was excessive implicitly by not knowing how much force the defendant was allowed to use. And finally, by refusing to give the instruction, the full self-defense instruction, the trial court denied Mr. Hague the benefit of the statutory right to stand his ground, to defend himself when he believed his life was at stake. In Lee and Bass, under the same circumstances, this court vacated the Court of Appeals decision and remanded the case for a new trial with accurate jury instructions. And Mr. Hague urges that the same result is required here. Moving on to the question of whether or not the trial court erred by refusing to allow Mr. Hague to testify that he knew that Tommy was a convicted felon. In Watson, this court said that in a self-defense case, to the extent possible, a jury should be placed in the defendant's situation with the same knowledge of danger as the defendant had in order to decide if the defendant's fear was reasonable. This makes sense because when a defendant claims self-defense, his state of mind is the crucial issue in the case, but of course, a person's state of mind is not subject to direct proof. So that's why the defendant must be given the opportunity to put the jury in his shoes so that the jury can see from his perspective, based on what he knew and understood, why he was afraid for his life.
So your friend from the state says that you can really only use this doctrine if the defendant knows sort of the underlying facts of the crime, or sort of at a minimum what the conviction was, if the name itself would sort of indicate the nature of the crime. So for example, in some circumstances, writing a bad check can be a felony. I think most people who knew someone had been convicted of writing a bad check would not fear, if they got in an argument with them, that that person may become violent. So what's your position here on the state's argument that your client didn't know that information?
Well, I think that cuts both ways. My client never made any bones about it. He was perfectly honest that he did not know what the conviction was for. But if you don't know what the conviction is for, it might be for armed assault, and you don't know what the conviction is for. And also, even if you don't know what the conviction is for, you know that this person has violated the law. And I quote in my brief, all of the disabilities that flow from having a felony conviction. We make all kinds of determinations as a society about all the things you can't do if you have a felony conviction. But the other thing is that it showed Mr. Hague, in Mr. Hague's mind, a former detention officer, that Tommy was not a law-abiding citizen. And this is especially true in light of the fact that Mr. Hague knew that Tommy regularly carried firearms and hunted. He'd seen him with a pistol multiple times. He knew he hunted on the field. And so this is someone, in Mr. Hague's eyes, who has no respect for the law. He does what he wants to do. And in Mr. Hague's opinion, this makes him less trustworthy, somebody to be more afraid of, somebody who will do whatever he wants to do. He's not a law-abiding person, and therefore Mr. Hague was more afraid of him for that reason.
Is being a felon a trait of character? Or is it a status?
That is such a good question, Your Honor. And I've kind of been around and around about it. But even if it was character evidence, he wasn't offering it for a character purpose. In his mind, because Tommy was a convicted felon and he regularly carried guns, despite that fact, Mr. Hague was more afraid of Tommy than he would have been otherwise. So you could say it's character evidence because it shows he's not a law-abiding person. But the crucial distinction here is that Mr. Hague did not then want to turn around and say to the jury, because he's not a law-abiding person, he was disobeyed the law in this instance. He wasn't trying to say that. He was saying, so it wasn't a character purpose. He was saying, because he's not a law-abiding person, he has his felony conviction, I was more afraid of him. And that goes to his state of mind, not for a character purpose to show that Tommy acted in conformity with that character trait that morning.
So if it's not a character purpose, is it 404B?
I think it falls under 404B, which is a rule of inclusion that only excludes character evidence if it is offered for a character purpose to show that the person acted in conformity with that character trait in the specific incident.
Okay, so I'm confused now.
Okay.
If it's not being offered for a character purpose, walk me through 404B dealing with the character evidence.
All right.
Prior bad acts.
Under 404B, prior bad acts are not admissible to show that a person has a character trait related to those things and acted in conformity with that character trait. But they can be offered for another purpose. And there's a long list in the rule about other purposes, but it also says that list is not exclusionary. And here, it was being offered to show Mr. Hague's state of mind, not to show that Tommy acted in conformity with the character trait in that instance. And it's really crucial here to note that Mr. Hague didn't need to prove that Tommy was the aggressor. He didn't need to show that Tommy acted in conformity with any particular character trait. The state itself admitted that Tommy was the aggressor. There was no question. The evidence was completely undisputed on that fact. So he didn't want to offer it for a character purpose, but he also had no need to offer it for a character purpose because the evidence already showed that Tommy was the aggressor, and the state admitted that Tommy was the aggressor and that all Mr. Hague had done was approach him to speak to him. So it just wasn't offered for a character purpose, and therefore, because Rule 404B is a rule of inclusion of relevant evidence, unless it's offered for a character purpose, it comes in.
Right, so, but you are offering character not for character's sake, you're offering it to show knowledge of your client, right?
My client's state of mind.
Right, and
Yes.
but you're offering the character trait to show state of mind, right? That he was a violent person, that he was a peaceful person, that he was a quiet person, that all of those sorts of things. So the character evidence comes in, but it doesn't come in because it's character evidence. That's excluded, as you mentioned. It comes in because it goes to your client's state of mind, which takes me back to the question, if we're dealing with character evidence, right, are we dealing with a character trait, or is it just a status as felon?
I think that all he wanted to say was, I knew that Tommy was a convicted felon, and I was more afraid of him because I knew he was a convicted felon. So that morning, when I was dealing with him, I was more afraid of him than I would have been otherwise if I had thought that he was a law-abiding citizen. So Mr. Hague's testimony was being offered, the knowledge that Tommy was a convicted felon was being offered to show Mr. Hague's state of mind, his fear of Tommy. The reason that knowing someone is a felon might be relevant is because, as I said before, you don't know what felony they may have been convicted
That
of.
gets back to my question of what I'm wondering is if the reason the state is asserting that this is the way the doctrine needs to be, that you have to be aware that it was a violent felony in a case like this, is because we as a society, so that belief that your client had would have to be a reasonable one in order for the judge to say, okay, you can explain this to the jury. And I'm just wondering if maybe what's going on here is that we as a society are not prepared to accept as reasonable the idea that every convicted felon, people can immediately assume just from that fact that they must have violent proclivities or that you need to be fearful of them. And that is essentially what was going on in the mind of the trial court here, is saying, without some information that your client had about what that felony was, this is not reasonable enough that I'm going to allow, it's too prejudicial. I just am not going to allow this testimony to the jury. So why is that wrong if that was what the trial court was thinking?
Well, I think it's wrong first and foremost because the question is not whether the trial court would have been more afraid of Tommy had he known that he was convicted of a felony, but whether Mr. Hague would have been more afraid. And Mr. Hague was more afraid of him because he knew he was a convicted felon.
For purposes of the crime that he was charged with, that belief would have to be reasonable. You would agree with me about that in order to matter.
Yes, I think that belief would be reasonable.
So what if the trial court was just thinking it's not reasonable to think that every person that's been convicted of a felony, not knowing what the felony is, must be a violent person or a dangerous person, someone I need to fear if I'm around them, that they may harm me?
Mr. Hague didn't want to testify that he was a violent person. He wanted to testify that he was somebody who had no respect for the law because he knew he was a felon and he had a felony conviction, and he knew that he regularly possessed guns all the time, which was committing additional felonies. That's what he wanted to testify to. And so Mr. Hague's state of mind is, this is a person who doesn't obey the law. And that was relevant. That made Mr. Hague more afraid of Tommy than he would have been otherwise. If Mr. Hague wanted to say he had a felony conviction and therefore he was more violent and therefore I can prove to you that he was the aggressor because he had a tendency to be aggressive, that would not have been permissible because Mr. Hague had no idea what he had been convicted of. But that's not what he was trying to accomplish. And that's why, again, going back to Justice Berger's questions, I believe that it was evidence that you could infer a character trait from. The fact that he had a felony conviction, you could infer from that, and Mr. Hague did infer from that he wasn't somebody with respect for the law. And you could infer from that he's more of a wild card. You know, he uses guns all the time, even though those are additional felonies. This is not somebody who, you know, plays by the rules and I can trust to be reasonable. I think those were the things in Mr. Hague's mind. He also testified that he tried to avoid Tommy, and the state mentioned in one of their interactions that he used the word de-escalate, you know, that he was sort of trying to calm Tommy down and end the conversation and go on about his business. So I think he saw Tommy as kind of an unpredictable person with no respect for the law, and he was more afraid of him for that reason. But he was not trying to get the jury to think that Tommy acted in conformity with a trait for violence. He didn't need to show the jury that. I mean, everybody agrees he violently shoved a 72-year-old man who was using a cane and wearing a cast. Nobody needed, I mean, there's no more evidence than that he could be violent. Mr. Hague didn't need to convince the jury of that, but he did need to, and he had a right to, put the jury in his shoes that morning to help them understand how things looked from his perspective. And so I think clearly this evidence was relevant, and because 404B is a rule of inclusion of relevant evidence, unless it's offered for a character purpose to show action in conformity with it, it comes in, and it should have come in, and that was an error.
I understand what you're saying is reasonable to me. I think, again, one thing the trial court may have been thinking is if the proposed testimony was that your client was aware that Tommy wasn't allowed to be carrying firearm or wasn't allowed to be hunting legally, that would be different than informing the jury, I'm aware this person's a felon. And what the court was trying to do in sort of a 403 analysis was, is this telling someone that the person been convicted of a felony, is there a tendency to sort of arouse a passion in the jury about how they feel about that person, that was the prejudicial part. And that it was just a wrong testimony was proposed to be admitted here.
Well, I am sorry I cannot quote the exact page numbers, but I will say that Mr. Hague's attorney did bring up that he was not allowed to carry a firearm when they were having this debate. He didn't say, exactly what I just said, that because he was not allowed to carry a firearm, he was obviously disobeying the law, and therefore he was not responsible, and therefore Mr. Hague was afraid of him. But he did bring that up. It was very significant to him that that Tommy repeatedly carried a firearm, even though he was a convicted felon. He brought that up in the trial counsel brought that up in the discussions of why the evidence should come in that Tommy was a convicted felon. I only have a couple of minutes left, so I will just say that the prejudice here is clear because Mr. Hague was not allowed this critical opportunity to put the jury in his shoes to understand where his mind was going that morning as things were happening. And because of the erroneous exclusion of the 404B evidence, there were redactions that absolutely destroyed Mr. Hague's credibility because it was crucial. He wanted to testify, or he told the 911 dispatcher that he could have called the law on Tommy a million times, but he didn't. But because of the redaction, they just would have no choice but to assume that Mr. Hague just insanely and stubbornly refused to admit that Tommy did have permission to hunt on the property. And it was crucial evidence of Mr. Hague's lack of malice, because what he's saying is, I knew he was a felon in possession of a gun. If I'd wanted to, I could have called the law on him. If I had been out to get Tommy, I could have done it. But I wasn't out to get him. I had this thing that I could have done, and I didn't do it. That showed lack of malice on Mr. Hague's part, and he didn't get that evidence in front of the jury. And in a case where he's claiming self-defense and there's no more crucial issue than his credibility was just left in tatters. It made it look like he was lying. And there's more to that, but I don't have time to go into that, but it is detailed in my brief. And I just want to very briefly say on the insufficient evidence of premeditation and deliberation that my learned counsel is right that this court has said that premeditation can be formed in a few seconds. This court has said that, but it is also true that in Korn, this court still looked at those factors to determine whether or not, in fact, there was substantial evidence that premeditation and deliberation had taken place. And in this case, it was not reasonable, and there was so much evidence that Mr. Hague did not go on the field to confront Tommy. He didn't even know Tommy was there, and in this case, there was insufficient evidence of premeditation and deliberation. Thank you.
Thank you, counsel. Rebuttal.
Just briefly, I want to comment about my learned colleague's statement that there was no choice for the jury but to assume that defendant was just being stubborn about admitting that Tommy had permission to be on the property when he said he knew he hunted there illegally. Well, that could mean a number of things. It doesn't necessarily have to lead to only the conclusion that the defendant's delusional. Tommy could have been hunting illegally out of season. He could have been hunting with the wrong implement. He could have been hunting beyond the allowed limit of doves. They were dove hunting, how many he could take with him. There's any number of things that a jury could have concluded from that evidence. The defendant here was not prejudiced by the exclusion of that evidence, as defendant suggests. Also, with regard to the stand your ground issue, the instruction given by the court included the fact that the defendant would have been allowed to use deadly force if he had reasonable belief that he had no other alternative but to use it. So the jury knew that this defendant was elderly, that he was wearing a cast, that he used a cane. He even testified that he didn't think he'd be able to get away. It's unlikely that this jury would have held against him a failure to retreat under those circumstances. So the jury had a basis for considering whether or not
Thank you.
his use of force
Thank
was
you,
reasonable.
counsel.
Thank you.
Your time's expired.